10 minutes, I feel, is a little too short to delve into any one issue in too much depth. So I thought of the other extreme, which is 10 issues in 10 minutes. Given that we live in an era of headlines and sound bites and instant gratification, I thought that this is just about it's opposite, and it's just about the level of attention span that we all have. So let's see how it goes. Now, the question posed today in this session is whether the law is guilty too. I think not, and that's because the problem, to my mind, lies in the implementation, in the enforcement of the law, and that's something which everyone has, that distinction is something which everyone has heard, often made. And the reason is that the law itself is intended to be something which, in the way that it's framed, is flexible, is something that is meant to last, something that is meant to endure. And so when you make a law, frame a law, articulate a law, you never do it with the kind of specificity that can take care of each and every situation that the law intends to cover. If you do that, then you run into the problem that it will apply to too narrow a set of scenarios when the purpose of the law is much larger and greater. Now, you might ask that, well, there must be something wrong with the law if in its implementation problems arise. Maybe there isn't enough clarity, there isn't enough specificity, but that's precisely the point. There can't be. And if you were to try to bring that to bear within the law, then you would make it far too narrow. So I think that is the distinction that people often forget, and the problem is not with the framing of the law, and the solution is not always with the reframing of the law, but it's about the implementation, how it's enforced, who's enforcing it, and where that implementation is going wrong. Now let's take another issue, which is topical, which is trial by media. Now, what do I mean when I say that? I mean two things. One is, of course, the obvious meaning, where you have a case that is at the stage of investigation or at the stage of trial, and you have the media constantly scrutinizing the case, talking about it, having debates about it, going into the course of the investigation, what the statements of the accused or witnesses may or may not have been, what the judge said, and so on and so forth, and the possible impact that they may have, that kind of scrutiny may actually have on the course of the trial. Now, the popular reaction is, well, it's a good thing, because trials generally don't go, is the perception, in the way that they're supposed to. And therefore, if there is this kind of scrutiny, if there is this spotlight, then that will only help matters. And we have seen that in a number of cases, it has helped matters and things have been fast-tracked, and what we believe to be justice has been perhaps done. Now, the other thing that I mean by trial by media is that immediately when a particular offense that is in the limelight, a particular incident takes place and it captures everyone's imagination, again, you see a slew of debates and discussions on TV channels round the clock, talking about what legislative change is required, what roadblocks there are in the law, and politicians and lawmakers are accused of not moving and acting fast enough. Now, according to me, there's nothing wrong per se with any of this. We are entitled, people are entitled to discuss these issues, to debate them, to have a view on these issues, and put the lawmakers on the mat. And to have this kind of scrutiny, and it's certainly healthy, and it has helped. But where I think the problem lies is the kind of debate and discussion, the level of debate, and in particular, the dogma behind the views that are expressed. A considered view, a measured view, a circumspect view, a view that deals in grays rather than in black and white is not considered sexy. It doesn't appeal to the camera. People want to hear unqualified, unhesitating views that are unequivocal and absolute. But the issues that spring up when this kind of discussion takes place cannot be resolved by absolutes. And that's the problem that I feel exists, which is that people express their views in a manner as if to say, well, this is my view, it is uncomplicated, and this ought to be and must be the only view out there. And if somebody tries to defend the position that exists by a more measured response, then they are branded as being a member of the status quo, possibly corrupt, and so on and so forth, not interested in change. So I think that, to my mind, is the problem with the kind of debate and discussion that takes place. And these are not issues on which we ought to be hasty, otherwise we will repent at leisure. Now let's take another topic that invites a lot of emotion: restrictions on the internet. Now, the perception and again the popular view and a view of a lot of young people in the country is that internet is a free space, a space where so many have been empowered. It is unparalleled in the kind of access and reach that it has provided to anybody who wants to voice their view. You don't have to be a journalist or somebody that a newspaper wants to speak to or interview. You can just put your view out there and millions may or may not read or listen to that view. And so it's an empowering medium, and any talk of restriction on speech on the internet evokes deep and very heated emotion. Now, I think that the outrage in reaction to the thought of restricting speech on the internet is somewhat misplaced for two reasons. One, because speech on the internet is not any special category of speech. Why should it be the case that speech on the internet receives any greater protection than any other speech in this country? If the law says that speech in a newspaper, speech on a television channel, speech in any public forum is subject to certain laws, such as of defamation, you can't slander somebody or destroy somebody's reputation based on something you know to be false. Why shouldn't that same law apply to the internet? I so far haven't heard any good justification for why the internet speech ought to be hallowed. The second reason is that if at all speech on the internet is to be dealt with differently and specially, it is in fact the other way around. The internet allows speech anonymously, without any accountability, without at times even being able to identify who the speaker is. With a newspaper, you can go to the publisher, the editor, the journalist concerned, and haul them up if they are responsible for something which falls foul of the law. What do you do with the internet? Instantaneously, speech which could be harmful, which the law recognizes as harmful, is transmitted all over, and it can have major consequences for the people who are objects of that speech. And so, all I say is that if at all there is a law which regulates speech, I don't see why that should not extend to the internet. Perhaps unpopular, but that's what I feel. Let's go to pendency of cases. That's the common complaint. Large number of cases stuck in court, don't go anywhere. What do we do? Now, again, there's not enough time here to go into issues of not enough judges, not enough courtrooms, so on and so forth. Those are institutional changes that, of course, are required. But let me, by way of an illustration, suggest certain other techniques. There's a retired judge of the Supreme Court, I won't say who was appointed to a particular legal tribunal. And when he took over, there was, of course, a long pendency of cases in this tribunal. So when matters came before him for hearing, and lawyers, as they are known to do, asked for adjournments, he said no. Go on or suffer a judgment. Now, in the first few months, 6 months, maybe 8 months, lawyers complained bitterly. There was a deep outrage, a lot of criticism. They all, told each other their tales of woe and how they were stuck in this court and that court and couldn't make it, and the gentleman judge was unsympathetic. But after those 6 to 8 months, they fell in line. They realized that this judge is not going to let us off. And so they made sure that then when they committed to a matter in that court and it was going to come up, they were more often than not there to argue the matter. And as a result, in a relatively short period of time, all that pendency was taken care of. Now, the problem is that these initiatives, and this is not just true within the law, I get the feeling that it is true with all our institutions, that change of this kind happens despite the system, not because of it. We have in this country an enormous human capital that just cannot be suppressed no matter what the system is. You have people who are committed, dedicated, brilliant, innovative, honest, and these people effect change in their own individual sphere no matter what the system is. But this change, more often than not, does not translate into systemic change, into capacity building. Now, that judge would ultimately cease to occupy that chair, and another judge would come and occupy the same chair. And it is very possible that the same pendency of cases will happen all over again. So the challenge is that how do you turn these individual initiatives of individual good judges, of whom there are a sizable number, into collective action, which results in at least some change, which can be achieved in the very near future. Now, one of the issues that interests me is the thought of whether court proceedings should be televised. Now, what's the argument for it? Most court proceedings, by law, are public. Anybody can go, sit in, watch the proceedings. There may be a special category that are in camera, have to happen behind closed doors, which are of a sensitive nature, but that doesn't apply to most categories. Now, if most proceedings are public, then why shouldn't they be televised? We are in the age of television media. Why should the country not know what is happening, what is being argued, what is the judge saying? Personally, I am against it. This is a good argument in theory, but the reality is that if television cameras were to come into the courtroom, it would, to my mind, have an entirely chilling effect on the business of the administration of justice. When I argue before a court, what I want most of all is for the judge to speak his mind to me, to convey to me why he is not convinced by my argument. What is troubling him or her? And it is only once I learn of that, once that is communicated to me, that I can persuade him to the contrary. Now, what will happen if a television camera is there? The judge will simply not say anything. Most of them won't, because they'll be afraid. They'll be concerned. How will it sound? How will people interpret it? Those who don't understand the legal processes, what will they think of it? They'll misunderstand. So the judge will only speak through his or her judgments. And that's very dangerous for the justice system, because the whole purpose of advocacy is to understand what is troubling the judge and try to persuade him and convince him of one view or the other view. And that interactive process would be destroyed. I don't think we are otherwise mature enough and ready enough for that kind of scrutiny. Having said that, it may not be a bad idea to at least have, for instance, transcripts of what was argued, not argued, and what comments were made or not made. This is typical in Western countries, and in fact, we have a whole lot of litigation connecting this to the previous issue, which arises out of what may or may not have been said in court by the lawyer when it was being argued, and therefore what may or may not have been conceded or not conceded. The reason is that any case is often heard by several different judges. And so various issues arise as to what was argued last time, and there's a lot of litigation that arises from that lack of clarity. Now, let me tackle very quickly corruption. No doubt, any financial corruption in the legal system, in the judiciary, is an indelible blemish. It is something that outrages us most of all, notwithstanding corruption elsewhere, because of the fact that the temple of justice has this blemish on it. Having said that, to my mind, on a daily basis, this is not an issue at all that worries us on a daily basis as lawyers. To give you a very small example, if you have, just take a figure, I mean, this is an absurd, false, and baseless assumption, but just for the sake of argument, if you have 30 judges in a court and 30 cases before them every day in a high court, and one out of those 30 in every courtroom, there is some financial corruption, you still have 29 cases in each courtroom multiplied by 30 courtrooms every day where there is no hint of any corruption. As I said, this is a baseless assumption, highly exaggerated, not true at all, but even if you look at it in that sense, it is not a daily problem. The daily problem, the real issue, is what I like to call intellectual corruption. The lack of the integrity, the laziness about hearing cases, adjourning matters, not doing what you're supposed to do, and not doing it in the manner that is required with the kind of sensitivity that the litigant expects, and that's a more difficult problem to tackle. Just a couple of points and I'm done. The court being interventionist, again, there's a perception that it is overzealous. At the same time, the justification is that other institutions have failed us. There's always a problem where and this is one of them, where the medicine or the solution is worse than the disease, or can be. The court is right, and I think it is justified. It is driven by the right motive. We can't impute any wrong motive, but the simple problem is this. A client, an expert who knows what the situation is, what the ground reality is, communicates to the lawyer. A lot is lost in translation. The lawyer is not an expert on the issue. The lawyer then puts the view across to the judge, who is also not an expert. And you have a second level of loss in translation. And ultimately, the judgment that you get is often misdirected. I think, let me just make one point and I'm done. Last point, which is this, that people often think that the law is something dry, there's a lot of jargon, there's a lot of rhetoric, it is esoteric, opaque, difficult for people to access. That is true in large measure, but I just want to say this, that behind the cold print of the law resides a great deal of emotion. The Constitution is a great example of this. You have a document which seeks to protect those who are unable to protect themselves. It seeks to engraft rights for the individual, to allow the individual to take on the might of the authority, of the majority. There's a great deal of humanity and emotion behind that thought. Lawyers, of course, are sharp talkers. They are masters of sophism. But I think the law perhaps is a little less guilty. Thank you.